People v. Pritchett, 25-93370. We'll continue that arraignment to September 8th at 9:40 a.m. Mr. Key, a docket call. Two 5-93361. We'll continue that to September 8th at 10 a.m. I presume that the prison may call in later this morning with Mr. Key. I'll inform them if they do. And Ms. Krajewski, docket call and contempt sentencing. We'll continue that to September 8th. That's file 25-93350. We'll continue that to September 8th, 9:50 a.m. We're back on the record, and then we're going to recall People v. Ray Darga, file 25-93366 and 93367FH. Counsel, you want to state your appearances for the record, please?
Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler, I represent Ray Darga.
All right, and I've been given a plea agreement and advice of rights in both these files. They are scheduled for an arraignment. So for purposes of arraignment, do you or Mr. Darga wish to have the original informations read?
Your Honor, Mr. Darga would waive the reading of the informations.
Okay, and is the forensic center referral requested?
No.
All right, so Mr. Darga, would you please raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Sorry,
I
did you
do.
say what? Okay, put your hand down then. All right, so Mr. Darga, a guilty plea hearing is an important event. It includes the waiver of constitutional rights you have. Let me know if you have questions or if you need to talk to Mr. Vogler some more. In file 366, looks like it'll be no contest to the misdemeanor MDOP. And Mr. Vogler, the reason for that, would that be a civil liability?
No, Mr. Darga does not have a recollection of it.
Oh, lack of memory. Any,
Yeah.
and do the people concur or consent to a no contest plea for that?
We do, Your Honor.
And the complaint and affidavit, can that be marked as a joint exhibit 1?
Yes.
Okay. They're marked as joint exhibit 1. All right, Mr. Darga, in file 366, malicious destruction of property less than $200 is a misdemeanor punishable by a maximum of 93 days in jail and or a $500 fine or 3 times the value of the property, whichever is greater. Do you understand that maximum?
Yes.
All right, and in file 367, defendant will be pleading guilty to count 2, 3, and 5. Mr. Darga, count 2 and 3 is resisting, obstructing police. Those are both felonies punishable by a maximum of 2 years and or a $2,000 fine with discretionary consecutive sentencing, meaning the maximum exposure could be 4 years for that. And count 5 is driving on a suspended license, second offense. That's a misdemeanor punishable by a year in jail and or a $1,000 fine. Do you understand the maximum penalty in that case?
Yes.
All right, and Mr. Darga, did you read and understand the rights listed on the advice of rights form that you signed?
Yes.
Do you have any questions for me or your lawyer about any of those rights?
No.
Now, those list all the rights that you give up when you enter a plea and you won't have a trial. Do you understand that? And do you wish to give up those rights and enter the plea today?
Yes.
All right, if I accept your plea, you give up any claim that it was caused by promises outside the plea agreement or by any threats. Do you understand that?
Yes.
Also, you lose the right to appeal when you enter a plea. And if you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on that appeal are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes.
All right. The plea agreement provides in exchange for your plea to those charges, the prosecutor will dismiss the remaining counts as well as the habitual notice. And there is a sentence agreement for a county cap, meaning that the maximum jail at the initial sentencing could be a year in the county jail, no prison. Do you understand that?
Yes.
I am not bound by that sentence agreement, meaning if I didn't want to follow it, I wouldn't have to. But if I did not follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yes.
That's unless you get in trouble between now and the sentencing, in which case you'd lose the right to withdraw your plea. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty and no contest?
No.
Has anybody threatened you to induce those pleas?
No.
Are they your own free choice?
Yes.
So, Mr. Darga, in file 366, how do you wish to plead to the charge of malicious destruction of property under 200? Guilty, not guilty, or no contest?
No contest.
All right, and I have reviewed Joint Exhibit 1. I believe it does establish a factual basis. Do you agree, Mr. Vogler?
Yes.
Do you agree, Mr. McLennan?
Yes.
All right, Mr. Darga, in file 367, we may have the numbers wrong on these. I've got 36. Okay. Okay, no, that's fine. Yeah. In file 367, how do you wish to plead to the charge in count 2, resisting obstructing Deputy Carson?
Guilty.
How do you wish to plead to the charge in count 3, resisting or obstructing Deputy Smiley?
Guilty.
And how do you wish to plead to the charge of driving on a suspended license, second offense?
Guilty.
Mr. Vogler, would you assist with a factual basis on that case?
I will, Your Honor. Mr. Darga, on May 13th of this year, were you driving an automobile on a highway in Presque Isle County?
Yes.
And you got pulled over by the police, is that correct?
Yes.
And following their investigation, they attempted to put you under arrest, is that correct?
Yes.
And as part of that process, they were attempting to handcuff you, is that right?
Yes.
And did you pull away from pull your arm away when they were trying to handcuff you?
Yes.
And there were 2 officers involved?
Yes.
At the time that you were driving that vehicle, was your license suspended?
Yes.
And had you previously been convicted of driving on a suspended license?
Yes.
Go ahead, Your Honor.
Okay, Mr. McLennan, you satisfied with that factual basis?
Your Honor, I may have missed it, but I just want to clarify that this incident occurred in Presque Isle County.
Yes.
Okay, I'm satisfied.
All right, Mr. Vogler, are you aware of any other promises, threats, or inducements?
No,
And do you believe I've complied with the court rule?
I believe you have.
Mr. McLennan, do you believe that are you aware of any promises, threats, or inducements?
No.
Do you believe I've complied with the court rule?
Yes, Your Honor.
Mr. Darga, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of those offenses, so I'll accept your plea. Agent Lesky, Mr. Darga, I think was sentenced within the last year, so I think this would be an updated PSI. Would we be able to have that done by the September 8th date?
I'll get it done here.
Okay.
Yes.
All right, we'll schedule sentencing for September 8th at 10:10 a.m. Anything further, Mr. Vogler?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
Okay, you're all set, Mr. Darga. And then you're going to come up with Poliandro, Mr. Vogler?
I am.
Okay, great.
Time to break this one down. Judge Aaron J. Gauthier presided over People v. Ray Darga with his usual mix of calm authority and procedural precision. This was a combined arraignment and plea hearing for two separate files, both resolved in one sitting thanks to a negotiated plea agreement. Darga, appearing with his attorney Mr. Vogler, waived the formal reading of the charges and confirmed no forensic center referral was requested. Things got interesting when the judge noted one misdemeanor plea malicious destruction of property under $200 would be no contest due to Darga's claimed lack of memory about the incident. The prosecution agreed, and the supporting affidavit was entered as a joint exhibit to establish the factual basis. The second file carried more weight. 2 felony counts of resisting and obstructing police and 1 misdemeanor for driving on a suspended license. Second offense, Judge Gauthier went through the maximum penalties methodically, making sure Darga understood exactly what he was facing. The plea deal was clear. Darga would plead to those counts in exchange for dismissal of the remaining charges and the habitual offender notice, with a sentencing agreement capping any initial jail term at 1 year in the county jail, no prison time. The judge also reminded him that this cap only held if he stayed out of trouble until sentencing. The factual basis came straight from Darga's own admissions under questioning by his attorney. He was driving in Presque Isle County, pulled over by police, resisted being handcuffed by pulling away from 2 officers, and did so while his license was suspended, having been previously convicted of the same offense. The prosecutor asked for a quick location confirmation, then both sides agreed the record supported the pleas. Judge Gauthier accepted them, noting they were made knowingly and voluntarily, and ordered a presentence investigation to be completed before sentencing in September. What stood out here wasn't any drama or fireworks, but rather the judge's consistent attention to detail, ensuring rights were waived properly, confirming the agreement's terms, and even noting that the no contest plea served a practical purpose given the defendant's memory claim. The tone remained professional but not stiff, and the process moved with the kind of efficiency that only comes when all parties have done their homework. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.